Hi, my name's Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case of Cohen versus Petty. This case was heard in the DC Court of Appeals in the year 1933. Cohen is the plaintiff in this case, and Petty is the defendant. John Petty was his full name. And this is a car accident story. As we jump into the facts, I'll just lay out the story briefly. It's not a long one. Mr. Petty was driving his vehicle, and he began to feel ill. So he turned to his wife, who was in the front seat. The plaintiff and her sister were in the back seat. So he turned to his wife, Miss Petty, in the front seat. Her name was Teresa. He said, "Teresa, I'm beginning to feel ill." And Teresa said, "Oh no, what's going on?" She turned over and, she didn't think much of it. She turned back, looked to the road. She looked back over at John Petty and noticed that he had fainted. He had passed out at the wheel. She hurried and, tried to grab a hold of the wheel and steer the car, but ultimately it was, there wasn't anything she could do. The car crashed off the side of the road. Miss Cohen and her sister were thrown from the vehicle and sustained injuries. So because the injuries were sustained, Miss Cohen and her sister brought suit against the Pettys, saying that they were negligent in the way they drove the vehicle, and John was negligent in the way he drove the vehicle, and that he should be held liable for the damages, i.e. the injuries done to the sisters. So the trial court ruled in favor of Mr. Petty, saying that because it was a sudden strike of illness, he couldn't have foreseen this, and it wasn't true negligence in this case. The Cohens weren't pleased with that, so they went ahead and appealed it to the DC Court of Appeals, and that's the decision that we are focusing on here in this video. So the ruling in the DC Court of Appeals was an affirmation of the trial court's ruling. The trial court affirmed, and they stated, I just want to read briefly from the case. "In the present case, the positive evidence is all to the effect that the defendant did not know and had no reason to think he would be subject to an attack, such as overcame him." When they say attack, they mean his fainting episode. "Hence, negligence cannot be predicated in this case upon defendant's recklessness in driving an automobile when he knew or should have known of the possibility of an accident from such an event as occurred." So he didn't know about this, is basically what the court is saying. There's no way he could have foreseen that he was going to faint. He had no history of fainting. He wasn't on any type of, drugs or medication that would have led him to faint. He had eaten breakfast that morning. So they ruled in favor of John Petty and said that the Cohens can't recover in this case. All right, so now that we have the ruling, we know the issue to be that one is not chargeable for negligence in a situation where they suddenly are struck in by an illness that they had no reason to anticipate. So that's kind of the ruling, and that's also the issue, the question in this case. Let's go ahead and jump into the ex ante implications, some incentives generated. So first would be, for the Cohen sisters, there's no method for them to recover. If they broke their femur or if one of them became paralyzed from this accident, they don't talk too much about the injuries. They say there were serious injuries, but they don't say specifics. But, if one of the Cohen sisters was paralyzed, ultimately she has no means to recover because of this freak accident. So, it doesn't seem intuitive to allow her to recover from John Petty, but it also just doesn't seem intuitive that she can't recover from anywhere, right? She didn't do anything to deserve this accident. So I just kind of want to draw on a couple other scenarios and see if it kind of pulls on the strings and makes you feel like maybe someone should be held liable. So envision you go in for brain surgery. You have a tumor in your brain and you need it removed. Well, the brain surgeon is working on your brain with some sutures. He's cut open your skull and he's in there. And all of a sudden, while he's doing that, he faints and his sutures slip and they hit the part of your brain where, your movement and nervous system comes from, and ultimately you become paralyzed forever. Well, should we be able to, recover from that doctor because he fainted while he was doing your brain surgery? I don't know. It might be a different case. If we're going to go off the precedent set here in Cohen versus Petty, we shouldn't be able to. But it doesn't seem intuitive that you wouldn't be able to recover from a doctor in that type of a scenario. Let's just throw a couple of wrinkles on the case and see if maybe that might change the opinion of the court, or if we think it might change the opinion of the court. First one was being if John Petty was a known narcoleptic. So a narcoleptic is someone who faints very often. If he was a known narcoleptic, could the Cohen sisters have recovered from him, right? Because John Petty knows that he faints often, and he knows that it's a possibility that he could faint while he's driving this vehicle. So that's one. What if John Petty had just recently started a new prescription medication? He had back surgery and his doctor put him on a new pain medication. And That was the third day that he had been on the medication, and all of a sudden he passed out while driving. Well, then maybe should we be able to recover from John Petty because he knew that when he was driving, he was under the influence of some type of prescription medication, and that there was a possibility he should faint? Or should we be able to recover from the doctor? If the doctor didn't explain to John the issue of, that it might cause him to faint in the future. So those are a couple of interesting questions. Finally, one more scenario I just want to generate is fasting is really big now in like the health community, and just overall, a lot of people are into fasting, right? Intermittent fasting, you'll hear about it all the time. People don't eat for 16 hours a day and then they eat for 8 hours a day. So in those types of scenarios, people's bodies can get weak, especially if they push the fast longer than, anticipated. If someone were deep into a fast while driving a vehicle, so John Petty, let's envision, is deep into a fast while driving this vehicle and then passes out, could he perhaps be held liable for the damages? Because the fainting could be shown to be a direct result of him not eating food for that period of time. So some interesting things to think about, some wrinkles on this case. Thanks so much for watching. I hope you have a nice rest of your day.